Better than your policy.
It's a wonderful use of the taxpayers' time, that one.
Yes, great use of taxpayers' time as well.
Thanks.
You can use that for all Wednesday.
Yeah. No win Wednesday.
First off, I've been ever accused of using psychobabble. Psychobabble.
I don't want that sort of
Order. The clerk cannot be heard.
You can't.
Members can take their conversations outside if they need to speak.
No win Wednesday.
Clerk.
Business item number 1474, standing in the name of Ms Faehrmann, relating to the Road Transport Amendment, Medicinal Cannabis Exemptions from Offences Bill 2021.
Mr President. Thank you, Mr President. I move that this bill, the Road Transport Amendment, Medicinal Cannabis Exemptions from Offences Bill, be now read a second time. Mr President, this bill has been to an inquiry, and I understand under the new standing orders there is an opportunity for me to give a further second reading speech now, but I won't take the time to do that. I will say that the inquiry I thought was very important for members in this place to understand how unfair these laws are. We had a number of very good, credible witnesses explain to us just how unfair these laws are, how they work in other jurisdictions, and really the need for these driving laws in New South Wales to get up to speed and get basically to make sure that they are now able to reflect the fact that cannabis, medicinal cannabis in New South Wales is indeed a legal medicine that has been available to thousands, tens of thousands of people in New South Wales for years. I'll talk more about this in my speech in reply, and I look forward to members' contributions.
Are any other members seeking the call? Minister.
Thank you, Mr President. Mr President, the government will be opposing the Road Transport Amendment, Medicinal Cannabis Exemptions from Offences Bill 2021. The government cannot support this bill and believes if enacted it would compromise our long-standing road safety principles, and I would hope those opposite would oppose this as well. Mr President, this government is committed to improving road safety. Earlier this year, Minister Faraway and I released the 2026 Road Safety Action Plan. It has new targets to halve deaths and reduce serious injuries by 30% on New South Wales roads by 2030. It demonstrates the Perrottet government's ongoing commitment to reducing unsafe behaviour and trauma on our roads, and includes a continued focus on reducing dangerous drink and drug driving behaviour. The plan builds on the success of the 2021 plan, which achieved its target of 30% reduction in road deaths over the decade to 2021. And I repeat that, it achieved that target. That's significant because of the efforts of this government. As part of the 2021 Road Safety Action Plan, this government introduced a series of reforms to strengthen drink and drug driving laws in 2018 and 2019. And in 2021, we also introduced the combined drink and drug driving offence. It was an important introduction of important legislation to keep people safe following a number of incidents which tragically took lives as a result of those motorist decisions to drink and drug drive. In New South Wales, we have a well-established approach to drink and drug driving that is aligned with other jurisdictions. And I welcome the interest of all members in improving road safety. However, there are real risks, real safety risks and uncertainties and impracticalities associated with this bill, which mean that it cannot be supported by the New South Wales Government. The New South Wales road safety policy focuses on deterring people from driving if they have taken drugs, as well as detecting drivers that show visible signs of impairment. This policy reduces the risk of fatal crash due to drug driving. In New South Wales, we have a two-tiered approach to tackle drug driving. There is one offence for driving under the influence, DUI, and this offence applies to a driver who, when stopped by police, is visibly affected by a drug. This is a serious offence, carrying penalties consistent with high-range drink driving. The second offence is for driving with the presence of a prescribed illicit drug in blood, urine or oral fluid. The New South Wales Mobile Drug Testing Program, led by the New South Wales Police Force, tests for detectable levels of 4 key drugs in oral fluid. They are ecstasy, THC or tetrahydrocannabinol, which is the psychoactive part of cannabis, cocaine, and methamphetamine, including speed and ice. And this random roadside testing of oral fluid is the most common way that drivers are detected and charged with a drug driving presence offence. As part of our recently released 2026 Road Safety Action Plan, the New South Wales Government has committed to continue delivering 200,000 mobile drug tests per year. This ongoing enforcement is important to achieving our committed road safety targets of halving...
Point of order.
Ms Cate Faehrmann on
I ask that
point
you
of order.
stop the clock, Mr President.
Mr President, I just wanted to check that the Minister's actually speaking to the right bill, because the bill is about medicinal cannabis and all she's talking about is road safety and illegal drug use, and it just sounds like she hasn't read the bill and has no idea what the
With
bill
a point
does.
of order.
Order. Yes. The Minister has the call.
I'm most certainly addressing the bill, Mr President.
I haven't heard any evidence to the contrary. The Minister has the call. There is no point of order.
And this is a serious matter that this government is addressing, having done so directly addressing drug and drink driving behaviour, Mr President. And that is our target of reducing our long-term goal of reducing and getting rid of serious trauma on our roads. As roadside testing can be undertaken anywhere, anytime, it's designed to deter drivers who have recently used illicit drugs from taking the risk of driving. We want to stop them before they get behind the wheel. This approach maximises the deterrence effect by enabling large-scale roadside testing that keeps New South Wales drivers and road users safe across the state. I turn to medicinal cannabis. In New South Wales, this government has a zero-tolerance approach to driving with prescribed illicit drugs. This approach is efficient, is considered best practice and therefore widely adopted across Australia. I'm aware of the growing use of medicinal cannabis to treat a range of serious conditions such as chemotherapy-induced nausea and vomiting, epilepsy and chronic pain relief. However, it's critical that people continue to be deterred from driving after they have used drugs that may impair their driving ability and are consistently present in our road trauma data. To support this, it's important that roadside drug testing continue to operate efficiently and effectively to deliver safety benefits to all drivers. Mr President, I'm advised cannabis medicines vary considerably and can contain THC, tetrahydrocannabinol, and CBD, cannabidiol. CBD is a non-psychoactive ingredient in cannabis and is responsible for the therapeutic qualities including anti-nausea and pain relief in medicinal cannabis. While medicinal cannabis typically relies on CBD, it can also contain THC. THC is the psychoactive component in cannabis that can affect the skills needed for safe driving and is found in both illegal cannabis and some medicinal cannabis products. THC can affect cognitive and motor skills necessary for safe driving, such as attention, judgment, memory, vision and coordination. To the bill. Most medicinal cannabis products are unapproved therapeutic goods, which means they have not been assessed by the Therapeutic Goods Administration for safety, quality or effectiveness. They can still be accessed as a treatment where clinically appropriate when approved treatments have not been successful. Mr Deputy President, there's strong evidence regarding THC use and road safety risk. New South Wales Health advises that patients should not drive while using a product that contains THC. Crash data in New South Wales shows that between 2016 and 2020, there were 253 fatal crashes involving drivers and riders with the presence of THC. Importantly, Mr Deputy President, this represents 16% of all fatal crashes recorded during that period. That is a significant contributing factor. With such a significant trauma profile, it's critical for any responsible government and Parliament, for that matter, to take a cautious approach to reviewing any changes proposed and to also consider the practical challenges and implications. The bill under consideration today would amend the Road Transport Act 2013 by excluding users of medicinal cannabis from the offence, relating to drivers driving with the presence of THC in their oral fluid, blood or urine if THC is the only illicit drug present and if it is taken as prescribed. Importantly, as THC is the same substance in both illegal cannabis and cannabis medicines, and critical to the operation of this proposed change, is that should it become law of this state, there would be no reliable way to distinguish at the roadside by the New South Wales Police Force whether the source of THC detected is illicit or is prescribed for medicinal use, or whether the driver has used cannabis illicitly in addition to their prescription. Roadside drug tests provide clear evidence that a driver has recently used THC, which is known to affect safe driving. All roadside drug tests are confirmed in the laboratory before further action is taken against a driver. However, the process does not determine drug concentration. Should this bill become law in New South Wales and the New South Wales Police Force attempt to determine whether THC from cannabis was, quote, administered as prescribed, end quote, by a doctor, this would require a blood sample by an authorised sample taker and require expert pharmacology review. And even with the concentration, current analytical techniques are unable to determine the source of the drug. Mr Deputy President, the outcomes of this bill would result in a much more invasive, uncertain and resource-intensive outcome for both law enforcement and administration. Any change would limit the ability for the New South Wales Police Force to deliver the high volumes of roadside drug tests that serve to deter drug driving, an approach that has community support and has been independently evaluated in Victoria as successful in saving lives. It would also be inconsistent with the policy settings across other major Australian jurisdictions which have comparable roadside testing programs. As I've said, honourable members, the current mobile drug testing program, modelled on the random breath testing program, is designed to reduce risk and address trauma on our roads. Together, random breath testing and mobile drug testing, combined with public education and our target safety programs, are deterring most people from drink and drug driving and changing unsafe driver behaviour. Every effort has been made by this government to deter high-risk behaviours like drink and drug driving. As part of the 2026 Road Safety Action Plan, the New South Wales Government has committed to continue to monitor drug driving research and developments relevant to drug driving policy. We've also recently established a Drug and Alcohol Road Safety Advisory Group to revitalise the strategy for drug and alcohol testing of drivers in New South Wales, including the scale of testing and testing processes, with a view to achieving greater efficiency, reach and deterrence of unsafe behaviour and trauma reductions. Mr Deputy President, I respectfully dispute the assertion that our drug driving laws are outdated. This government is focused on saving lives on New South Wales roads, not encouraging unsafe driving practices. As I've outlined, this government is committed to keeping up to date with best practice evidence. The New South Wales Government will continue to take a cautious approach to driving regulation and legislation on our roads and will consider the safety of all road users. But the New South Wales Government will maintain its focus on strong measures to help us reach our ambitious road safety targets and keep everyone on the roads safe. For those reasons, Mr Deputy President, we do not support this bill.
Thank you. Further speakers? I call the Deputy Leader of the Opposition.
Thank you, Deputy President. I rise to speak on this bill on behalf of the opposition. I'm grateful to the work that the Standing Committee on Law and Justice has done on this bill. I think it really has helped shed some light on some of the complexities, some of the contrasts that you've heard between these two positions, one put by the mover of the bill and then in reply by the government. I do want to recognise the work of the opposition members of that committee, and that was Rose Jackson and Greg Donnelly on that inquiry. There are some real complexities here, but that inquiry report really goes on to show some areas of agreement shared by this committee. And the first of those was that they really did hear some evidence from some people really affected by this problem, and I think there's a real acknowledgement of that in the report. Both sides of the House, through the committee, recognise this, and that is certainly something that I have had put to me by other MPs, that they are now dealing with this as an increasing issue as people are using medicinal cannabis more often. They are seeing an impact here. People who, because of the restrictions in the law and the way these tests work, they are unable to move around in the way that they'd like to. They are more isolated as a result, some losing work because they can't do those things. So an acknowledgement, I think, by many MPs, particularly in some parts of the state, and the North Coast is one of the areas where this debate has been the strongest, that there is a problem here on the ground. It is a growing problem as medicinal cannabis is used more often. The committee, in fact, went further than that, and I note the work of the committee chair, Chris Rath, who's in the chamber, and particularly his forward. There was one part that I particularly wanted to highlight to the House, where he said this on behalf of the committee. It was noteworthy that diverse stakeholders highlighted the need for more research into the interaction between the use of medicinal cannabis products and driving impairment. The committee has encouraged attention to and investment in the task of carefully considering the specific effects of medicinal cannabis products on essential driving skills so that the paramount importance of road safety is maintained. So an acknowledgement of the need for more research, a call for investment in that research. I think some indication of the work that this committee has done to grapple with the issues here, the issues that you can hear in those two contributions, and try and find a middle ground through this issue. I'll indicate for the opposition in relation to this bill that we won't be voting to support this bill today. I do acknowledge that there is a problem. I do acknowledge there's a growing problem as this becomes more prevalent in our community. But we do believe that there is that more research required that's highlighted in this case by the chair, but I think also in a range of the committee discussions. And you can see that in the contribution the government's made, raising some real complexities, some real issues with this. I'll turn to the government remarks and just deal with a couple of those. Firstly, the minister's right to point out the terrible issues that we've had on our roads, some very high-profile incidents which have attracted the thoughts and sympathy of the whole House. It is true that this House has acted to change the law in relation to some of those things and tighten offences. That shouldn't stop us dealing with this issue, but I just want to acknowledge the comments that the Minister made. She's right to draw attention to the fact that some of these medicinal cannabis medical solutions are approved, some of them are unapproved when it comes to the way the federal government deals with this, and that's one of the things that our committee members had referred to. She's right to draw attention to the fact that too many people are dying on our roads, and some of them are impaired by drugs. That is a contributor to these road deaths. I didn't agree with her observation that anyone in this debate is encouraging unsafe drug practices. I think that's a characterisation I wouldn't accept of the mover of this bill. I think that, I accept the mover of the bill has been driving this agenda for quite some time and is doing so in good faith. I want to disassociate the opposition from that comment. At the heart of the... I'll make those observations, Deputy President, in relation to the government contributions here. But I think it does demonstrate the issues, the extent of the wideness of the debate here and the issues that still need to be resolved before we can deal with what we acknowledge is a real problem here. I'll deal with some of the matters in the bill. The bill amends the Road Transport Act 2013 to provide an exemption to people who test positive for THC in their system while driving if it was obtained and administered in accordance with the Poisons and Therapeutic Goods Act 1966 or a corresponding act of another state or territory. Importantly, the defence only applies if THC is the only illicit drug present in a person's system at the time they test positive. The person must have consumed a legally prescribed medicinal cannabis product, and importantly, they have to have consumed the product according to the guidance of their doctor. That guidance will include how to use the product in such a way as to avoid driving while impaired, as is the case for other prescription drugs like opioids. We acknowledge that this bill does not provide a catch-all defence for persons with a medicinal cannabis prescription who are demonstrably impaired. The bill, one way to put it, or one way that's been put, is that the bill provides a comparable medical defence for those found driving with morphine present in their system if it was consumed for medicinal purposes. The Minister has made some references to the current situation in New South Wales, that if a person tests positive to THC while driving, they're found guilty of an offence under Section 111 of the Road Transport Act 2013, and there have been a number of charges to strengthen penalties in New South Wales, as we've discussed. The inquiry itself received 106 submissions. There was quite a high level of engagement with this particular upper house inquiry. There were obviously legal and health policy experts and advocacy groups, but it was really the inquiry submissions from some of the persons who were directly affected, people who were living through the experience of having serious health challenges, using medicinal cannabis, and the challenges that not being able to drive, having to make their way through their ordinary life, the impact that was having on them, that really, I think, was the most valuable work of the committee, because it's so hard often to get that evidence. So the fact that those submissions were drawn out, I think, is helpful in grappling with this complex issue. Of particular note, the committee also heard evidence that some prescription medications allowed to be present in the body while driving can cause greater driving impairment than medicinal cannabis. Again, a sign of just how complex this debate can be. One of the issues it really highlighted was the issue of isolation and disadvantage that the barriers to driving especially impose on those living in regional and remote areas. I've referred to one of those areas, the North Coast of the state, but this applies equally in other regional areas of the state. Many of those residents don't have access to public transport, don't have access to the other sorts of ways to make their way around the state that you might if you're living in Sydney, and that was a particular issue highlighted. I do want to, yes, I really want to emphasise that issue of isolation and disadvantage that is impacting on people. One of the advocates who's really drawn attention to this, I will mention specifically, and that's David Heilpern, the former magistrate in the Lismore Local Court. I think he's been a very strong advocate for what this is doing to the community in that North Coast area of the state, based on what he saw sitting on the bench. And I do want to recognise the specific contribution he's made to this debate, really highlighting some of the impact this is having on ordinary people's lives. I think I just want to contrast the two issues to really highlight where the opposition is coming from. The real issue here at the centre of this, and the reason why I think the Chair's call for more research is such an important one, is that the central issue here is that one can be impaired or not impaired, but still record a positive test. That's the central issue, making this a very complex issue, where someone who is undertaking a legal activity, someone at a vulnerable point in their life with a health issue, using legal medication, not impaired, could still record a positive test. That's the issue that's creating this problem here. Yeah. Our issue is the government's position doesn't really acknowledge, as I understood it, that you could be not impaired but still test positive. I agree with some of the remarks that the Minister made about of course there are risks here, but we have to acknowledge you could be not impaired but still test positive. And the opposition's issue with the bill is that there's no acknowledgement there that you could be impaired, you could be dangerous on the roads, but a defence still could take place when you present before the court system. So that's the complexity, if I can put it in its simplest form, and that's really why we believe there does need to be some work here. So I just want to summarise the position as we see it going forward. I think I've been as clear as I can be on the position on the bill. We won't be supporting that today. Yeah. Where do we go from here, though? I think building on the good work of the committee, I think we can say there's a problem here. There is an issue which is impacting on the lives of citizens in New South Wales, and it is something that the House and the Parliament should continue to look at. We accept the case made by the committee and the chair. More research is required, and there are institutions that are well placed in New South Wales to perform that research. We accept the case for more investment, and that is something that in government we would look to do, invest in that research in order to move this issue along and do so rapidly. And the fourth step, and this is something we would look to initiate in government were we successful in March, we believe a further review of this matter by the Centre for Road Safety, that expert body in government which has done so much good work, along with the independent research investment, would allow us to really resolve some of the issues that are here, sort through some of the complexities, and then come back with some further advice so that the Parliament could consider what steps could be taken to deal with this problem that this report has so highlighted. Having said that, I will commend. I might acknowledge the bill in front of the House.
I'll call the Assistant President.
Thank you, Mr Deputy President. I rise on behalf of One Nation to contribute to the debate on the Road Transport Amendment Medicinal Cannabis Exemptions from Offences Bill 2021. Just from the outset, I want to say that we too will not be supporting this bill. I just want to get onto the record, though, that this bill is not about the prescription or use of medicinal cannabis, but actually about driving while it's in your system. And I think that's important because I too sit on the Law and Justice Committee along with the Honourable Greg Donnelly, and he's just disappeared. Yourself, of course, Mr Deputy President, and the Chair, Mr Rath, was here as well. And we heard lots of evidence that day, but it became confluted between the two about the actual use of medicinal cannabis and the driving of it. Now, I believe the use of prescribed medicinal cannabis is not an issue, right? If it's prescribed, it's legal. Where the issue comes, though, is the increased risk of motor vehicle collision when cannabis is in your system. So I believe that this bill is dangerous, and it's dangerous not in the use of prescription medication, being the cannabis, but actually driving while it's in your system. And also this bill is deficient. And I'll come back to the deficient parts later. Now, I'd just like, and I know that the report has been circulated and all members of this House has had an opportunity to read the report that the Law and Justice Committee did, but I want to draw your attention to some aspects of that particular report. Now, I go to page 5 of the transcripts where Professor Ian McGregor, Academic Director, Lambert Initiative for Cannabinoid Therapeutics, University of Sydney, gives evidence. Now, I would suggest, and I think I'm being fair in saying that, is a proponent of the bill. But let's have a look at some of his evidence. And now I'm not going to read the whole transcript onto the record, but this is the crucial parts. He says, and these are his words, crash risk data are complex. But the best controlled studies are telling us that what we call the odds ratio is 1.1 to 1.4 if you are acutely intoxicated with cannabis. In other words, it's an increased crash risk of 10% to 40%. That is about the same as 0.04 or 0.05 blood alcohol concentration. This is coming from not a Member of Parliament, but a professor at the university telling us about the increased risk of driving whilst cannabis is in your system. He goes on to talk about the need for further studies and research, which is reflected by what the Honourable John Graham said. And then I question Professor McGregor myself, and I say, let's take you to your statement just recently. In your opening statement, you said the risk level of a crash goes up. Then answer to my colleague, Mr Donnelly, you have said anywhere between 10 to 40%. Monash University says 50%. You dispute that, but we're not here to split hairs. There is an increased risk though. Do we agree? He says that's what the evidence, and I say where that sits we don't know, but there is an increased risk. Ian McGregor, yes. We don't actually know in the case of patients, he says, until we run a trial like Amber study, we won't know whether that impairment is really. And I say, can I rudely interrupt you? I apologise, but I want to hone in on this. We don't know at the moment were your exact words. He says, in the case of patients, we don't know whether the crash risk is increased or not, having previously told us that the crash risk increases by somewhere between 10 to 40%. So I'll let you form your own opinion as to the evidence of the professor. We then have evidence from a Michael White, and unfortunately I haven't recorded his portfolio, but my understanding he's an academic from South Australia. I say, Dr White, does the presence of THC in somebody increase the chances of them being involved in a motor vehicle accident if they were to drive a vehicle? Is there an increased risk factor? In his evidence, he goes, we agree so far that THC positive drivers seem to have a 40% increase in the risk of crashing. I say, thank you, Dr White, I just rudely interrupt you here because we're on the clock and I want my other colleagues to have their chance. Did you listen to any evidence earlier this morning, particularly the evidence presented by Professor McGregor from the University of Sydney? White says, no, I haven't been listening, but I've read Ian McGregor's submission and it looks to be an excellent submission to me. Let's bear in mind that that submission said the increase in risk chances of an accident go from 10 to 40%. So we have another doctor or another academic saying it's an excellent submission. I said, yes, certainly, but Professor McGregor in evidence here this morning, albeit he is probably a proponent of the bill, if I can suggest that, says that there is an increased risk of motor vehicle crashes of anywhere from 10 to 40%, and not that it has no effect at all. White says yes, and I acknowledge that that is the common accepted view, 40% from the literature. That is the view from about 3 perhaps recent literature reviews, including my own, unless you go the one step further and trying to work out if some of these studies are affected by biases. I agree with Ian McGregor that the normally accepted view would be 40%. Now, I could go on further, but I won't. I think I've made the point, and the report is available to all members. So what this bill is doing, Mr Deputy President, it's asking us as legislators to pass legislation that will increase the risk factor of a motor vehicle collision. That's what it's asking us to do. The evidence from academics and professors said that there is an increased risk between 10 to 40%. How could we possibly legislate in all due conscience to increase the risk factor to drivers on the roads of New South Wales? That would just be completely irresponsible and reckless on our behalf. Now, I note the time and I like to try and finish my submission here, if I can, for the benefit of all members of the chamber. I would just talk about the deficiency in the bill. Let me just explain the practicalities of this from a police officer. So a motor vehicle is stopped at a random drug test. The police officer approaches the vehicle, says, me driver, you're going to go a random breath test here, lick the stick, right? The stick comes back positive. The driver says, well, hang on a second, hang on. I've got a prescription here for medication, and presents it to the police officer. Now, well and good. But how do we know that the THC that's been detected in the system of the driver is in fact the prescription one? How do we know that old mate hasn't pulled a few cones or ripped a few bongs before he's got into the car, driven down the road and then says, well, hang on, here's my defence, I take prescription medication. Further to that, how do we know that he has taken the prescribed amount? Now, the prescription might say take 1 tablet, old mate's taken 5. How do we know this? We can't detect this because the bill is deficient in allowing for that process. The bill is also deficient in terms of the onus of proof. And I refer members to evidence from, and I'm going to apologise in advance here in case I get the pronunciation of the name wrong. It's Ms Rose Khalil Izaida, who is a member of the Criminal Law Committee, New South Wales Bar Association. Now, in her evidence, I asked her at part somewhere, we talked about the bill and the defences and the mechanisms of the bill, and I say to her, but the bill in its current form doesn't take it far enough, does it, in terms of the explanation of it? She said, this has been set out in our written submission. At the moment, there is perhaps some need for clarification about precisely how that might work in practical terms of the onus of proof, where the defence lies and who needs to prove what if it proceeds to court. So the bill is deficient in the experts' eyes of members of the Bar Association. The bill is dangerous in that it increases the risk for users of drivers of motor vehicles in the state of New South Wales. It would be irresponsible of us to support this, and I think I will finish my contribution there. Thank you.
Thank you, Assistant President. Minister, you're seeking the call? Minister, you're seeking the call? Yes.
Sorry. Mr Deputy President, to suit the convenience of honourable members, I suggest you do now leave the chair and cause the bells to be rung at 8 p.m.
To suit the convenience of members, I'll now leave the chair and cause the bells to be rung at 8 p.m.
The honourable member.
Thank you, Mr Deputy President. I rise to contribute to debate on the Road Transport Amendment Medicinal Cannabis Exemption for Offences Bill 2021. In outlining the government's opposition to this bill, I feel it is critical to highlight the rationale of the New South Wales approach to drug driving. Our policy settings align with other jurisdictions and with other countries. We are not the first or only jurisdiction to face a question of how to minimise potential harm to road users. Statements in the community have been made about alternative approaches to drug driving, both in New South Wales and around the world. And it is important to be aware of the differences in context of programs and best practice. Mr Deputy President, to that end, I thank the Standing Committee on Law and Justice, chaired by my colleague, the Honourable Chris Rath, for its report on the bill delivered in August of this year. I also thank the stakeholders and members of the public for making submissions which carefully considered the impact of drug driving. I note the committee elected not to take a position on the bill, but to have put forth evidence to be considered during our debate here tonight. Mr Deputy President, the approach to drug driving in Australian jurisdictions uses high visibility, high volume roadside testing to create an environment that deters people from driving if they have recently taken drugs. I would hope my fellow members would agree that high visibility, high volume roadside testing is an appropriate approach to keep people safe on New South Wales roads. The mobile drug testing program is modelled on the random breath test, the RBT program, which began in 1982 and has been highly successful in deterring drink driving. Since that time, trauma from fatal crashes involving alcohol has dropped from about 40% of all fatalities to the 2018-20 level of just 18%. In real numbers, Mr Deputy President, 389 people were killed in alcohol-related crashes alone in New South Wales in 1980, compared to the 51 in 2020. The change in public attitude to drink driving did not happen overnight. It took a consistent commitment to public education and appropriate penalties, as well as a large-scale testing by the New South Wales Police. Our drug testing program is smaller and a relatively new program. I note that the proportion of crashes where illicit drugs were a factor has remained fairly steady over recent years. However, this must be considered in the context of the increasing use of drugs, THC, by the general population, according to the National Household Drug Survey. Mr Deputy President, the evidence is clear. It shows that mass random screening directly correlates to a reduction in drug-related road deaths and injuries. We see consistently from research that drivers who see and experience testing are less likely to take the risk of driving after they have used drugs or alcohol. That is why similar drug testing programs operate across Australia, and it is why Australia is considered to be, and I quote from the National Drug Driving Working Group 2018 report here, at the international forefront of combating drug driving. More recently, independent evaluation of the Victorian Random Drug Testing program conducted by the Monash University Accident Research Centre found that their increase in roadside drug tests was effective and highly cost beneficial, and was estimated to have saved a significant number of fatal and serious injury crashes per year. Likewise, New South Wales's approach to medicinal cannabis is consistent with other Australian jurisdictions. It is also consistent with the Assessing Fitness to Drive guidelines, the National Medical Standards for Licensing, which are adopted by all Australian licensing authorities when assessing a licence holder's medical fitness. The guidelines include a new section on medicinal cannabis and notes that THC can cause cognitive impairments that degrade the ability to drive safely. Most Australian jurisdictions test for THC in mass screening, presence-based roadside drug driving programs similar to New South Wales. No other jurisdiction has an exemption specifically for medicinal cannabis. Tasmania does have a medical defence for any prescribed drug. However, I am advised this reflects differences in the way drug presence offences were previously enforced in the state of Tasmania. While this could provide some method to consider a change in legislation or policy in New South Wales, I would make the following points. In practice, drug testing numbers are also much lower in Tasmania than they are in New South Wales, so the impact on government services from operating this defence is very different. For example, I understand that Tasmania conducted approximately 5,000 roadside drug tests per year over the last couple of years. This number is compared to the New South Wales Government's commitment to conduct 200,000 tests per year. While the Tasmanian population is obviously smaller, proportionally New South Wales conducts 2.5 times more drug tests than Tasmania. Mr Deputy President, any weakening of the general deterrence approach would therefore be expected to have a more significant impact in this state. Interestingly, the ACT decriminalised recreational cannabis in January 2020 to allow adults to possess a small amount of cannabis for personal use. However, the ACT did not amend its road transport law to allow a defence for the use of medicinal cannabis. Also worth noting is that medicinal cannabis have been introduced into the Victorian and South Australian Legislative Councils. Medicinal cannabis bills. The Victorian bill was introduced in 2019 and the South Australian bill was introduced in February 2021. At this stage, neither of them have progressed any further. In Victoria, an expert working group was established to consider approaches to managing medicinal cannabis and safe driving. The working group included representatives in the areas of health, road safety, justice and academia. The working group's report is current and detailed, looking in depth at the risks, the challenges, the opportunities of a comparable bill to the one before us. The report also considered what is known and not yet known about the specific risks associated with medicinal cannabis. Mr Deputy President, similar to the Standing Committee on Law and Justice in considering the comparable bill before the House today, they did not make any recommendations and did not recommend progressing the bill. I think that shows that there is not enough evidence to adopt this bill without potentially impacting drug driving. The government is agile and is open to amending or introducing new policies as needed where they have merit and where there is a need. As part of the 2026 Road Safety Action Plan, the New South Wales Government has established a drug and alcohol road safety advisory group to revitalise the strategy for drug and alcohol testing of drivers in New South Wales, with a view to achieving greater efficiency, reach and deterrence of unsafe behaviour and trauma reductions. Also, under the plan, this government has committed to continuing to monitor drug driving research and developments relevant to drug driving policy. Speaking of monitoring research and other programs, I know that some people will probably wonder why we have not followed the example set by other countries which have an exemption for medicinal cannabis. It is very difficult to compare the approaches to combating drug driving in international jurisdictions compared to those here. Even within countries that allow a defence for medicinal cannabis, drivers must prove they are not impaired, which typically involves providing blood samples blood samples. Notably, those countries do not have mass roadside screening programs and the deterrence benefits that they do offer. Australia is the only country with a widespread random mobile drug testing program for detection of drug driving. This is because governments across major jurisdictions in Australia believe in the benefits of these programs and the results back it up. I note discrepancies in international jurisdictions mean there is less focus on general deterrence. This means that in order to operationalise how the New South Wales Police would test for THC through blood samples in those other countries, it is likely to be less onerous as a proportion of the population, simply because so few people would be stopped and tested in the first place. Another difference is that many of those other countries do not allow medicinal cannabis for the variety of conditions that it can be prescribed for here. In the United Kingdom and Ireland, medicinal cannabis can only be prescribed for 3 conditions. These types and conditions or illnesses are generally not consistent with a person being in a position to safely drive. While other countries have different types of road safety challenges and perspectives about enforcement which inform their approaches, the bottom line is that the trauma challenge in New South Wales is real. In New South Wales between 2016 and 2020, there were 253 fatal crashes involving drivers and riders with the presence of THC, representing 16% of all fatal crashes recorded during that period. Because of these significant numbers, it is important to cautiously consider the bill in the New South Wales context and not just adopt changes because another country takes a different approach and when it is not aligned with the best practice evidence of the National Drug Driving Working Group. As I've said, Mr Deputy President and honourable members, our current approach to drug driving is designed to reduce risk and address trauma on our roads. This government continues to implement initiatives to deter high-risk behaviours like drink and drug driving. Mr Deputy President, the government does not support this bill.
Are there any further speakers? The Honourable Chris Rath.
Mr Deputy President, I will go through the government's position shortly, but I did want to start by making some initial observations about the work of the Law and Justice Committee that I was proud to chair. And I do want to thank the members of the committee for their work, in particular Ms Cate Faehrmann for all of her work and for bringing this bill before us. I know that it might not exactly be the outcome that she wants tonight, but I do think that it has given all of the members of the committee and I think this chamber a lot to think about. which is a job well done. Also to the Honourable Wes Fang, the Honourable Taylor Martin and the Honourable Lou Amato from the government, as well as the Honourable Greg Donnelly and the Honourable Rod Roberts and Rose, and the Honourable Rose Jackson, who was, I think, a substitute member as well, which is why it escaped my attention. I remember talking to Rose at one of the after the inquiry, and we realised that there wasn't all that much difference between our position on this, and I think that's the importance of these committees in the Legislative Council, unlike potentially the other place where you do get that great collaboration between members. And people often think that probably Rose Jackson and I have nothing in common, but when you actually sit down and talk about these issues, there's a lot more in common than people might think. I think that through the inquiry, what we realised is that this issue is so complex. On one hand, navigating it, because on one hand there is the issue of freedom, and on the other hand safety, and I think that what we are currently seeing is a problem where you have people who are prescribed medical cannabis who may take medical cannabis potentially before going to bed at night, and then the next morning they wouldn't be able to drive to work or drive to do their groceries or to go and do essential things that they need to do to get on with their lives, because they would be potentially pulled over and determined to be impaired, even though there is no impairment per se. And really the issue is, and the Honourable John Graham mentioned this in his contribution, is the issue of better research that needs to take place, because it's not like alcohol. It's not as simple as doing a breath test and getting a blood alcohol concentration of 0.05 and saying that this is the line where everybody above 0.05 will be charged, but those below are fine to drive. That is not the case with cannabis. The case with medicinal cannabis is that it's a yes-no, it's binary. It's either impairment or no impairment. There is no simple scale when it comes to cannabis, and that is why the research, and why I made a deliberate point of including that in the chair's forward, as well as it being detailed throughout the report, is so important, because I would like to see, and hopefully we do see in years to come, a situation where this will not be an issue, where people who do use medical cannabis will be able to have some type of blood alcohol concentration equivalent, and there will be a scale where it's determined that at a certain point there's impairment and below that point there isn't. Whereas mere traces, where there's no impairment at all at the moment, could prohibit you from driving. And I think we do have to acknowledge that our heart goes out to those people who all are caught up in the system, unfortunately, who are determined to be impaired, who aren't actually impaired and then therefore can't drive and can't go about their ordinary day. But the problem that I have with the bill, and seeing this throughout the inquiry, is that the flip side argument is just to say, well, let's just allow anybody with any amount of impairment drive. So it doesn't matter if you're completely impaired, completely unable to drive, you're completely reckless, versus someone who would have mere traces from potentially using medicinal cannabis long before. And that is the real problem where we sit, and that I think that the government and from the contribution of the Honourable John Graham, the opposition, lean on the side of safety and not allowing people who are with impairment to actually drive. Whereas I think that where the Greens are sitting, leaning more the other way in terms of their position in terms of the people who do use medicinal cannabis that should be allowed to drive to go about their ordinary day. And I think there is a lot of merit in that argument, but I think that the research is really important so that we can overcome this issue in the future, and hopefully it won't be an issue for much longer to come with scientific advances. But I will say that overall it was an excellent process that the Law and Justice Committee went through, hearing from stakeholders on both sides who delicately considered the impact of drug driving and balanced the considerations of road safety. Mr. Deputy President, driving is a privilege that comes with the responsibility of keeping yourself and others safe on the road. Measures introduced by the government to address drink and drug driving have been pivotal in reducing road trauma over decades. The government has introduced significant reforms supported by enforcement, public awareness campaigns and targeted programs to continue protecting road users from the dangers of drug driving. And this is a track record that we are proud of. Mr. Deputy President, as part of the previous Road Safety Plan 2021, the New South Wales Liberal National Government strengthened penalties and enforcement of both drink and drug driving by introducing drink and drug driving reforms. The reforms included the introduction of penalty notices coupled with automatic licence loss for lower range drink and drug driving offenders, the extension of mandatory alcohol interlocks to mid-range drink driving first offenders, and the option for police to apply vehicle sanctions at the roadside for high-risk drink driving offenders. A key aim of the reform was to ensure penalties are consistently and swiftly applied to prescribed concentration of alcohol and drug presence first offences. In February 2015, the mandatory alcohol interlock program was introduced by the New South Wales Liberal National Government for high-range drink drivers, all repeat drink driving offences and other high-risk offences where a driver refused to be tested. Evidence has shown us time and time again that alcohol interlocks are proven to significantly reduce the risk of drink driving reoffending. New South Wales has an established vehicle sanction scheme in place for high-risk offences to immediately reduce the risk of a driver engaging in further high-risk behaviour. Since December 2018, vehicle sanctions can be imposed by police at roadside for repeat high-risk drink drivers. The government also introduced in June 2021 a combined offence for drivers with illegal concentrations of alcohol as well as illicit drugs. The combined offences recognises that alcohol and drugs separately increase crash risk, and together they amplify that risk. The combination of drugs and alcohol increases the risk of a fatal crash by 23 times. And we did hear the contribution by the Honourable Rod Roberts before with some of that evidence in terms of those people who do take medical cannabis and how there can be an increase in the risk of those people on the road. And as I said before, that's why this government leans on the side of safety as opposed to the side of being a bit more lax in its approach. This is a figure we cannot ignore and is an important consideration behind why the government opposes this bill. The laws send a clear message to drivers that putting themselves and others at risk by combining alcohol and illicit drugs will not be tolerated. Enforcement, education and a strong penalty framework all act to deter unsafe behaviour like drink and drug driving. The Liberal National Government has strongly supported these enforcement measures through education such as the Plan B drink driving campaign, which highlights the impact of driving whilst impaired and encourages people to make alternative arrangements to get home safely. Mr. President, the government has a strong track record on providing a holistic approach to addressing drink and drug driving. This involves the government continuing to deliver 200,000 roadside drug tests each year, expanding mandatory drug and alcohol testing policy to including testing of cyclists in case of fatal crashes, delivering new and enhance education programs for drink and drug driving offenders to reduce reoffending and build on recent reforms. The government cannot support this bill knowing the negative impact it will have on road safety. The 4 prescribed illicit drugs which are detected under the mobile drug testing program were found to be present in 23% of fatal crashes in New South Wales between 2016 and 2020. THC was a factor in 16% of all fatal crashes. Of the fatal crashes involving illicit drugs during these years, between 50 and 70% each year involved drivers who tested positive to THC. Over the same 5-year period, 2/3 of all crash fatalities occurred in country New South Wales. Of those fatalities where THC was a factor, 72% were in country New South Wales. In 2020, THC was present in nearly 60 deaths of the total 264 fatal crashes that year. These are grim statistics, Mr. Deputy President, that must be considered in the context of this bill. We also know that in 2020-21, over 50% of positive samples from MDT contained THC. That is over 8,000 samples, and about 1/3 of all positive samples showed more than one drug present. Roadside testing can be taken anywhere, anytime, and is designed to deter drivers who have recently used illicit drugs from taking the risk of driving. Under the Road Transport Act 2013, it is illegal to drive, occupy the seat of a vehicle, or supervise a learner with the presence of prescribed illicit drug in blood, alcohol, or urine. Illicit drugs prescribed for the purpose of the Act are THC, cocaine, methamphetamine, and ecstasy. These are some of the most commonly used illicit drugs as reflected in the road toll. Deterrence is important because of the strong evidence on the impairing effects of THC. The impact of THC use on road safety risks is well established globally. Consistent with the trauma outcomes in New South Wales, evidence shows that THC can affect cognitive and motor skills necessary for safe driving, such as attention, judgment, memory, vision, and coordination, and can increase the risk of drivers by 40%. Research commissioned by Victoria, when a similar bill was introduced there, made the same findings. The government cannot ignore this. Between 2017 and 2019, there were 144 motor vehicle controls with the presence of THC involved in 142 fatal crashes. Over half of these were people aged 30 years of age, and 1/3 were over 40 years of age. If the bill were to be passed and some cannabis users were able to claim an exemption or a defence, it would complicate and potentially jeopardise the effective operation of the MDT program and the message it sends. As I said before, Mr. Deputy President, while I empathise with people who are taking medicinal cannabis under prescription and are directed by their GP, there is just not sufficient evidence that when combined with driving, medical cannabis poses no risk to other road users. That is why, as Minister Faehrmann said, that the committee, the inquiry, did not come to the conclusion that that it was free from risk and that it should be recommended to this place. The Perrottet government is committed to our strong track record on reducing drink and drug driving behaviour on New South Wales roads. Together with a large suite of other initiatives in the plan, we are steering New South Wales towards the ultimate goal of zero road trauma. Unfortunately, as highlighted by the Minister and my parliamentary colleagues, the bill before us is not consistent with reducing unsafe behaviour and protecting all road users for the risks posed by impaired drivers. It would be unfair to those other road users for the New South Wales government to support this bill. I significantly, or I certainly hope that in the future we can resolve this issue, that the research improves, the technology improves, that we do have a situation where people who use medical cannabis aren't caught up in the current difficult situation that they are in and unable to go about their daily lives as we all take for granted. But given the very important balance when it comes to safety, I do not support this bill, and nor does the government.
Thank you. I rise to oppose the bill. Before the House, the Road Transport Amendment, Medical Cannabis Exemptions from Offences Bill 2021. And congratulate the Speaker that I'm following for an excellent presentation that you probably don't need to hear from me. Now, but I still think it's good for me to second his speech and support what he was saying, which was excellent. I'm a member of the Joint Standing Committee on Road Safety and have seen the terrible impact of drug driving on motorists and pedestrians across our state. Regardless of whether the drug is prescribed by a medical practitioner or not, the question that should be asked is whether the user should drive. There are numerous legal drugs prescribed by that prevent the user from driving while it is in his system or her system. In fact, It is illegal and contravenes the Roads Act. This prohibition also against various opioids for the abuse for purpose of pain relief. The same prohibition applies to cannabis. This should continue regardless whether the cannabis was prescribed by a medical practitioner or not. If a light to moderate amount of alcohol is consumed the night before a driver goes on the road, then he or she will be quite comfortable and unimpaired from driving. The same cannot be said for the consumption of cannabis, the right to drive. Cannabis slows down our reactions and reduces our ability your ability to respond to situations. This drug changes your perception of distance and time. Lowers your concentration, reduces your coordination and makes you drowsy. Cannabis users often don't realise their driving
isn't going away, but we need to get the science right, which is why we are committed to doing the research. I would say this as well. All of the evidence that we do have, and it's not enough, partly because by and large cannabis is an illegal drug and that makes it more difficult for us to invest in the evidence base, but we should do that anyway, is that at the impairment risk for someone who is taking medicinal cannabis consistent with their prescription is similar to low-level alcohol. So the reality is, if you are so concerned with the potential risk here, you've got to be consistent and you've got to stand up and say the blood alcohol level should be 0. And to be honest, the people who are putting that case, I at least credit them with consistency. The people who are saying you can't have any alcohol, not one glass of wine, not one beer, and drive, they have at least a consistent position. But it is utterly inconsistent. It is utterly inconsistent to say we are prepared to accept a risk level associated with a blood alcohol level of 0.05, but we're not prepared to accept a similar risk level with someone who has taken medicinal cannabis. It's not consistent. Either you accept that there is a level of risk associated with some of those activities, or you say no, nothing. Now, the difference at the moment is that the measurement capacity with the blood alcohol level is the research that has gone into establishing what that looks like is clearer than with medicinal cannabis. Hence the need for the research. Hence the need to establish a framework for medicinal cannabis use that is consistent with the one that we use for alcohol consumption. And when we have done that research and when we have that framework, this is something that we do need to seriously consider. So I just wanted to say I really thought that the inquiry was good. It aired a lot of the issues, and the key recommendation that I think it found was that there is a genuine issue here, there is a genuine inconsistency in the law, and it is something that we have to deal with. We cannot not deal with this issue. It is something that we are going to have to continue to put on the agenda, because we cannot have a situation where people have to choose between their livelihood and their job and taking a medicine that they have been prescribed in a completely legal way by a doctor to deal with their pain and suffering. That is an impossible choice to put the community in, and we as legislators have a responsibility to resolve that.
Alrighty, any further speakers on the bill? If not, the Honourable Cate Faehrmann in reply.
Thank you, Mr Deputy President. And I have to say from the outset, really, thank goodness that the Honourable Rose Jackson did get up and speak then, because I was fearful that I was living in a parallel universe, to be honest, in terms of the contributions from everybody in this place. Was like I had a bill before the Parliament to allow people to drive while taking illegal cannabis, completely stoned, that I was trying to completely change the road safety laws to allow people to drive stoned. No, that's actually not what this bill before us does. And, you know, I will kind of say again, thank you, Ms Jackson, for coming up and actually talking about what the issue is. And it's the fact that this is a legal medicine that, in fact, I think we've got more than 300,000 prescriptions now across Australia, up to 72,000, a little bit more people, patients across Australia who are taking this drug, this medicine, legally prescribed by their GP, often because they have tried so many other legal prescription drugs as well, like opioids, to deal with chronic pain, to deal with PTSD, to deal with epilepsy, to deal with so many other issues that haven't worked. Prescription drugs haven't worked, and medicinal cannabis has been life-changing, has been life-saving for these people. That's what we're talking about. And yes, it was this Parliament, as well as the federal Parliament, that has introduced legislation to make medicinal cannabis legal. So let's be clear again. We're talking about a legal prescription drug that currently people cannot drive because they are fearful, and rightly so, of losing their licence, because that is what this current law does. It treats people who are taking a legal drug, legal medicine, completely lawfully, as though they are consuming a drug that is currently illicit. And that was what the Minister, Natalie Ward, when you addressed the...
Point of order.
Point of order.
Mr Deputy President, I respectfully... I respect the contribution of the honourable member, but she is, with respect, mischaracterising what my colleague and I have put before the House. We have addressed the bill before the House. We have not in any way characterised illicit drugs or otherwise.
Okay.
I'd ask that she be drawn back to her contribution to the House, not mischaracterise what my colleague and I have made in our contribution to the House, and we can go back and check Hansard if necessary.
Okay. I don't uphold the point of order. Ms Faehrmann has the call.
Thank you, Mr Deputy President. And some of the language that has been used during the government members' contribution to this debate, you know, we've got high visibility policing for a reason. We stand by our zero tolerance approach to illicit drugs. We are committed to road safety. We've got a road safety plan that is about reducing dangerous drink and drug driving behaviour. These are the lines, the speech, this is whatever was in the speech notes that government members were given to speak to this bill. I'm just literally not sure whether people read the bill who wrote the speeches for you.
Okay, there's a point of order.
Mr Deputy President, I ask that the honourable member be drawn back to her contribution in the debate, and it is disrespectful to other members to characterise what they have contributed to the House as being handed to them. We have given serious consideration to this matter, and it is disrespectful in my submission to characterise it as being handed to us. These are road safety issues.
Okay, well, Minister,
we've made our contribution.
Well, Minister, the suggestion that someone might have been handed notes isn't unparliamentary. It's not an offence against the standing orders. There is no point of order. Please sit down and let the member finish her speech and reply.
Thank you, Mr Deputy President. So I will go on to what the contribution from the Honourable Rod Roberts, who I also say from the outset, the Law and Justice Committee, the inquiry that looked into this bill, committee members I think engaged very genuinely. It was a very good inquiry. Witnesses, yes, from both sides. I tell you what, it was a harder job to find witnesses who were dead against the bill, but we did find some. But we all did. I think it was a good job, basically, on that committee. But I do just want to refer to some of the evidence and just to expand it a little bit more that the Honourable Rod Roberts was referring to, because it's really important. This is what the crux of the situation is, I think, because quite a few government members mentioned these stats, and I think they've been selectively talked about. So the Honourable Rod Roberts talked about, you did make the great point, it's a great point, that being acutely intoxicated is the equivalent of driving with a legal blood alcohol limit. Nobody kind of wants acute intoxication. I think, let's be very clear, this isn't about encouraging anybody to drive impaired. That's not what the bill before us is about, even though, again, it seemed to be a big part of the government's contribution to to the entire debate. But the Honourable Rod Roberts quotes both Professor Ian McGregor and then Dr Michael White in his contributions. So I have the transcript before me from, in fact, when both of those academics, those legal experts, provided their evidence. And in fact, Professor Ian McGregor does talk about cannabis intoxication causing a 10 to 40% increase in crash risk. He says acute cannabis intoxication. But it's just important to look at what he is saying. Professor Michael White is also asked about that 40%. So Michael White says, yes, 40% from the literature, there is an increased risk of crash by 40%. And he says that none of the papers I'm aware of on cannabis and crashing have tried to work out where the cannabis came from, whether it was taken medicinally or recreationally. My understanding would be that medical users would be taking it regularly, and often the findings on regular users is that they're not as impaired or probably not impaired at all. And they'd be taking it, I think, in doses that would be less likely to be impairing. And then he says, is it possible for me to say one more thing about the 40% increase in crash risk. And he says the important thing to note is that even if it is the commonly accepted 40% rather than perhaps the 0% that I suspect it is, that is very low. Alcohol at 0.05, the legal level, doubles your risk of crashing. That is 100%, right? So we're talking about the 40%. Alcohol at 0.05, the same expert that a number of witnesses have quoted today in terms of increasing the crash risk by 40%, alcohol at 0.05% increases it by 100%. Cannabis at 40% versus legal levels of alcohol, again I'm quoting the Michael White here, is a lot less. If you look at other things, the use of a motorbike increases the risk of crashing 30-fold, Mr. Deputy President. That is 3,000%. I think sometimes the focus is on the wrong things. Again, he's still talking. If you look at all of the road safety problems, including other drugs, benzodiazepines, opioids, etc., cannabis is way down at the bottom of the list as far as crash risk goes. And that's if you accept the 40% and not my 0%. If you accept my 0%, then there's no risk at all. I think the crash risk from cannabis needs to be put into context. It is a very small risk compared with almost any other cause of concern to road safety people. So that's Michael White. So I think it's very, this was put by the Honourable Rod Roberts as what is this bill doing? It's asking us to increase the risk factor of driving. Well, the witnesses, all of the witnesses before us who were asked this, who were expert in this, in the in the Law and Justice inquiry, said very clearly the risk of all other factors, such as alcohol, such as benzodiazepines. In fact, they were even talking about the risks of, for example, the risk of getting 7 and 8 hours sleep compared to 6 hours sleep. For example, sleeping 6 hours per night was associated with a 33% increased crash risk compared to sleeping 7 or 8 hours per night. Antidepressants are associated with an approximately 40% increase in crash risk. So, again, what this bill is asking is for a simple medical defence for those who are caught during a roadside drug test, not driving recklessly, not driving impaired, simply pulled over, for example. Let's use a random roadside drug test as an example. Simply pulled over, asked to take a test and found with THC in their system. If they have a script that has been provided by their general practitioner that is a valid script, and they're not driving recklessly, and they haven't pulled over because they're driving recklessly or they're driving as to pose a danger to others, then they have a medical defence, because they could have taken that medicine 24 hours ago, because this is what we also know. They could have taken that medicine 24 hours ago and clearly they're not impaired because they're not driving recklessly. It is disappointing that we're here after, I introduced this bill and second read this bill quite a few months ago now, and I do know that hundreds, in fact thousands of people who are directly impacted by these laws have contacted MPs in this place. I know that they've contacted key figures, ministers, as well as opposition leaders and opposition MPs, urging them to support this bill. I agree as well with some of the comments that we know that more and more people are going to be taking medicinal cannabis. The rate of the increase of use of medicinal cannabis over the last 6 months, 1 year, 2 years is absolutely astronomical. So more and more people are discovering the fact that medicinal cannabis is working for them when no other drug works for them. And I want to thank the many hundreds, if not thousands, in fact, of people that have contacted their MPs and have contacted me to tell me their stories. There was one man who is living in regional New South Wales, and I'll note that this law is particularly difficult for people in regional New South Wales who do have to make the choice between taking this medicine, the only medicine that will work for them, that will relieve their chronic pain, and actually driving and being able to drive to the nearest town or drive their loved ones around. This is just one email that I've received in recent weeks. One man in his 70s, so he wrote to me telling me that he suffers from chronic pain, sleep disorder and anxiety, and has been diagnosed with osteoarthritis in both shoulders and his spine. He was on a cocktail of pain medication that he told me caused more side effects than the pain it relieved. So the man eventually tried medicinal cannabis, which finally gave him relief from his pain. Hundreds and thousands of people are telling me the same thing. But he was forced to quit medicinal cannabis because he didn't feel he could continue to rely on his wife to drive him everywhere. So that man is now back in severe pain because he cannot drive because he cannot take the medicine he's been legally prescribed from his GP, even though he's not impaired. There's also the story of Scott Ford, who was a patient at the inquiry. He was a patient witness at the inquiry. And I'll just read a portion of his opening statement, just so members can also hear about Scott Ward. So Scott said, "I regularly use medicinal cannabis to manage chronic pain. I'm a military veteran and have had pain issues for around 10 years now. My injuries have significantly limited my capacity to work, to keep myself productive. I run a small beef cattle farm. I was a long-term prescribed opioid user. My dosages just kept going up and the opioid medications became more and more ineffective over time. I had to change my approach to managing my pain, and the solution I found was medicinal cannabis. I have found the medication is extremely effective for managing my conditions and is also safer than the previously tried opioid medications. I experience no intoxicating or ill effects when taking it as prescribed." I'll repeat that. I experience no intoxicating or ill effects when taking it as prescribed. The downside is that I can no longer legally drive in New South Wales. I live in a rural area and being able to drive is crucial. If I can't drive, I must be completely dependent on others to go anywhere. At the moment, when I need to drive somewhere, I go early and delay having my morning dose until I return home. By doing this, there's no chance that I'm impaired since I've not medicated for more than 12 hours. Although, I tell you what, I've spoken to a lot of people who say that the THC does stay in their system for longer than that. As he says, however, I would still fail a test as I would have detectable amounts of THC in my system. I would be guilty of the offence of driving with an illegal substance in my system, even though the substance has been obtained and used legally. I would strongly urge the inquiry, and let's change that to this Parliament for this, to support this bill so that users of medicinal cannabis can be acknowledged as genuine users of legal medications and not be treated as criminals. So clearly, Mr Deputy President, no one needs a maths degree to work out that this bill isn't going to pass tonight. I will just just say to the Honourable Chris Rath, who was the chair of the Law and Justice Committee, I do appreciate your contributions tonight. From your side of the chamber, I think you clearly did understand and do understand the issues, and I appreciate you putting on the record that it is an issue. I think you get that it's an issue, and I want to acknowledge that, and I certainly hope that in the new Parliament we have kind of people in the right portfolios, I suppose, and people with the understanding of this issue. people with common sense really and compassion who actually understands what's before them, that we can get a change very, very soon after the next election. Tens of thousands of people in New South Wales are severely impacted by this law. They are severely impacted by this law. And I know quite a few people are actually watching this tonight because they are so desperate for this law to change because it is impacting so severely on their lives or their loved ones' lives. So I want to say to you that this isn't over yet. Yes, this bill has been voted down, but change is inevitable. We will get there. Thanks for all your support and, let's do this.
Yay, hear, hear.
Right, we have before us the motion that this bill be read a second time. This is Ms Faehrmann's bill relating to the Road Transport Amendment Medicinal Cannabis Exemptions from Offence Bill 2021. All those in favour of the bill say aye.
Aye.
Those against say no.
No.
I think the noes have it.
The ayes have it.
A division is required. Ring the bells.
Pass the ball. Bill Brooks. Bill Brooks is Louis XVI coming back from Versailles. And the French Revolution started, they're on the ball. And he goes, everything's so green. Should have contributed to the fight.
Steve well, certainly unwelcome to me. Others I'm not so sure about. This issue cannot run in the medicinal cannabis bill. The problem is we don't have a measurement there. We can test for presence but not impairment. There is people impaired just because someone's not driving erratically doesn't mean their reactions aren't slow. So if someone was to run in front of them, they wouldn't just be too slow. Press the brake. It's a really huge route. People on other prescription drugs are also impaired. Yeah, but they are, and they still drive. Tested for those.
What do you got against School of Rock?
Is it killjoy?
No, I don't think so.
No, my time here.
That's right.
I'm doing what I want.
Good time. That's right.
What are you going to do, sack me?
No,
It's just too entertaining. I'm finding it too entertaining.
How was the Mexican? All right? Not enough chili because you can't sleep.
I've had to restrain it.
Yeah, okay.
Oh, okay. Sorry. I'll withdraw that.
Thanks for
We're not middle managers. Only 55 minutes to go.
Really?
This is the new regime I've ushered in.
Very good.
This is I was the architect of the kitchen.
It has, it's really simple. It'd be interesting
Lock the doors. The question is that the Road Transport Amendment Medicinal Cannabis Exemptions from Offences Bill 2021 be now read a second time. Could the ayes please stand? I appoint as the ayes. Miss Abigail Boyd and the Honourable Emma Hurst. Emma Hurst.
Get into it. Try your own.
Peter must have read the bill.
No drinking.
Yeah.
Oh, back on the ball.
He was the hydroponic beer and ice cream cones. He was up into it.
This is called compassion. That's what this is called. This is called science, evidence, compassion, reason. That's what this is called. All the people on the committee know it. This is called keeping people at work. This is called keeping people independent, functional, and out of pain.
Yeah, John. Not the no. Charlotte is joining your petition. She's outraged. No, like free. Charlotte came in here collecting.
Could the ayes please resume their